Sanford Police Department. Taking out the summary. This is my summary, but it's not an official record. I talked to Mr. Delarionda. I'd leave it in, but it's I created it.
Right. Did he approve it? Did he approve it?
No, I'm taking it out of the, yeah.
Okay, so that declaration from the City of Sanford will come in without objection
Correct.
as Defense Exhibit 25?
Mr. Delarionda is who I spoke with, so I don't want Mr. Guy and...
Yeah, Judge, if we could just wait till he gets back, I think
Okay.
it's okay.
And then, well, what I also will announce, just so we're clear, and then Mr. Delarionda can finalize it, is
Here he is.
oh, great. Mr. Delarionda was just putting in the evidence or the exhibits we had talked about. I took off.
Yes, I apologize.
It's okay. I took off the summary, so that's not in it.
Right.
But
We
the
have,
rest
we have
is.
no objection to that, Your Honor.
Okay, and it'll come in as Defense Exhibit 25. What is the next one?
Next one, Your Honor, is the letter documenting that my client, from Florida Department of Agriculture and Consumer Services, documenting the existence of my client's concealed weapons permit and a very poor copy of it.
Any objections?
no objection.
That'll come in as Defendant's Exhibit 26.
And the last one is the the CD and the event report documenting the sixth of 6 calls that my client placed in the past 6 months before the event. The state had played 5, this is the last one. And
Any
We have no
objections?
objection to that either.
Okay, that'll come in as Defense Composite Exhibit 27. That's it?
I believe that's it, Your Honor.
Okay.
There was, and Your Honor, the layout that was presented, the state has no objection to it being entered.
Okay, and that would be Defense Exhibit 28. We could call that a still board of the crime scene.
Thank you.
Okay, you want to look through your stuff and make sure you have it all?
Yeah, I think we do. There are a couple more we'll enter, but we'll do that just for the court's planning purposes. We have this witness, which we'll finish, then there are 2 very short witnesses.
Okay, Mr. Zimmerman, sir, I spoke with you this morning about your rights to testify if you want to, and the fact that you do not have to testify either, and the jury cannot consider that in their deliberations of whether you testify or not. Did you have an opportunity to talk to your attorneys about whether or not you want to testify in this case?
Yes, sir.
Do you need some more time to talk to your attorneys about that?
No, Your Honor.
Okay, and if you'll please just raise your right hand for one moment.
You solemnly swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, and Mr. Zimmerman, like I said before, you're aware that during this trial you have the absolute right to remain silent. You do not have to say anything, do anything, or prove anything. Is that correct?
Yes, Your Honor.
And you also have the right to testify if you want to. Do you understand that?
Yes, Your Honor.
And I've given you an opportunity to discuss with your attorneys whether or not you want to testify in this case, and you have indicated that you have had those discussions.
Yes, Your Honor.
And have you made a decision, sir, as to whether or not you want to testify in this case?
I object to that question.
Okay, overruled. Have you made a decision as to whether or not you want to testify in the case?
I object to that question. I think that's Mr. Zimmerman.
Overruled. The court is entitled to inquire of Mr. Zimmerman's determination as to whether or not he wants to testify. Mr. Zimmerman, have you made a decision as to whether or not you want to testify in this case?
No, not at this time, Your Honor.
Okay, and when is it that how long do you think you need before you make that decision?
Your Honor, may we have an opportunity to speak? The case isn't concluded yet.
I understand that, and I've asked Mr. Zimmerman if he needed more time to talk to his attorneys, and if he does, I will afford it to him. Mr. Zimmerman, how much more time do you think you're going to need to discuss this with your attorneys?
I assume it would depend on how long the recesses are, Your Honor. At the end of the day,
Okay, well, if your attorneys have finished with 2 witnesses before the end of the day, do you think that you would then know whether or not you want to testify?
On Mr. Zimmerman's behalf, that
I am
decision...
asking your client questions. Please, Mr. West.
I object to the court inquiring of Mr. Zimmerman as to his decision about whether or not to testify.
Your
at this-
objection is overruled. Mr. Zimmerman, I will give you more time, sir, to discuss this with your attorneys. Thank you very much.
Let me approach on an unrelated matter.
Yes, you may.
ask that the picture at least have.
Mr. Root is here. Are we ready to bring the jury back in?
Yes, Your Honor. Yes, Your Honor. Yes,
Oh,
Your Honor.
okay, let's go ahead and bring the jury back in.
Jury is present, Your Honor.
Please be seated. Welcome back, ladies and gentlemen. I hope you enjoyed your lunch. While you're getting settled in, I'm going to ask you my questions. If your answer is yes to any of the questions, please raise your hand. During the lunch recess, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology? Thank you. No hands are being raised. And finally, did any of you read or create any emails, tweets, text messages, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. Mr. O'Meara, you may continue.
Thank you. Good afternoon, sir. When we broke, I was just beginning to talk to you, and I wanted to go back to your cross-examination and a couple of questions that came to mind. You were asked by Mr. Guy whether or not you had listened to what we are calling the non-emergency call, which is the one in which Mrs. of Mr. Zimmerman's presentation, if that evidenced to you some type of anger or frustration or whatever it was by Mrs. Zimmerman. Did you had an opportunity in your experience as law enforcement to hear people in angry, upset, and frustrated ways?
Yes, sir.
Okay. Have you actually been involved in situations where you had to try and break up disputes, be they domestic disputes or fights, where people are yelling and screaming at each other?
Yes, sir.
And has that been sort of throughout the entirety of your career?
Yes.
Is that just one thing that police officers do as a part of their job?
Yes, sir, it is.
Have you seen and heard people in various states or stages of anger and hatred and ill will as they're yelling at people or each other?
Yes.
Using that basis as an experience foundation for your testimony to this question, was any of that
more of a frustration about the totality of everyone he's called in on, or an element in and of itself, not specifically one particular person. My interpretation of the comments he made were, in general, that
For Mr. Martin,
no.
there was another expletive that Mr. Guy questioned you about. Could you even hear the words effing punks when you listened to the tape?
Initially, no. That was something that you really had to try to break down and listen to.
At some point then, when you went back to listen to it enough to hear it, did there come a time when you ever go back and listen to it enough where you actually could hear the words?
Yes, the interpretation, but again, it was after being told they were there.
Similar question then, based upon your years of law enforcement experience, did those two words evidence to you any ill will, hatred, or spite that Mr. Zimmerman evidenced towards Trayvon Martin?
No, not individually.
And it was your understanding from your review of that telephone call that the frustration was aimed towards whom?
I would say
That is calling for speculation.
There were two questions that Mr. Guy asked you, and that was, one, about a responsible gun owner, and two, about other options that Mrs. Zimmerman may have had. So keeping those two questions from Mr. Guy in mind, was there anything in Mr. Zimmerman's use of his firearm that you would consider to be reckless?
no,
Why not?
because the use of the firearm was...
Judge, I'm going to object as to the motion previously heard.
I might be heard on that. This question was,
Okay, well, then approach.
yes.
Thank you.
Can I continue?
Yes, you may.
Mr. Root, based upon your training and experience, was there anything in the way Mrs. Zimmerman handled his weapon that night that was dangerous? I mean, obviously danger whenever you shoot a weapon, but did he do it in a way that was unreasonably dangerous?
No.
Again, I'm going to object to the same objection as to our limiting motion.
Okay. Overruled. Move on to your next question, please.
Yes, Your Honor. And I told you about two questions that you were asked. The other question was whether or not, in your opinion, based upon the facts and circumstances that existed at the time of the shot, whether or not Mrs. Zimmerman had any other options available to him.
Again, Judge, I'm going to object to this call for speculation.
Thank you.
I think he's already testified as to options as a response to a question from you, so overruled.
Judge, and I would object to, again, the limiting motion and the content of his answer.
Overruled.
So, Mr. Root, based upon your training and experience, and knowing what you knew about the facts surrounding the event that night, particularly at the moment of the gunshot, did Mrs. Zimmerman have any other options?
Based on my knowledge and understanding of him, the environment, the situation, the totality of everything, I don't believe he did.
There was inquiry as to whether or not you took this case on for the pure notoriety of it. I want to ask you some questions about that. Did you? Is that the main reason why you took on this case?
Absolutely not.
For whatever purposes, certainly with some of the benefit of having a high-profile case, does that or has that impacted in any way on any of the answers to your questions presented either by me in direct examination or in cross-examination?
No, because the same type of negative media coverage comes from this case as positive media coverage. Nothing had any influence on my answers other than my evaluation of the facts as I understand them from this case.
Does the possibility of some future payment to you from me for your testimony here today, did that impact at all in the way you presented your testimony?
Not at all.
The question was posed as to how many times you've testified as an expert. I think you said this is your first time testifying in a self-defense case?
In a criminal trial, yes, sir.
How many times have you testified in a criminal case?
Oh my, I couldn't quantify a lot. I mean, throughout a 22-year career in law enforcement, many times.
Okay, have you ever been cross-examination by a prosecutor?
No.
Normally you are actually on the side of the state, correct?
Yes, this is a complete opposite of where I normally sit.
I want you to presume for a moment that you don't have any information about where the fight started. Forget the location of Mr. Zimmerman's little small flashlight or anything else like that. Focus for now just on the 40 seconds of screaming and the injuries. With that set of circumstances, would you change your opinion at all about Mrs. Zimmerman's lack of options?
No, I would not.
Would your opinion be the same even if there was 2-minute delay between the ending of Mrs. Zimmerman's phone call and the event that happened which caused those injuries?
No, that would be irrelevant to me.
What are the only real relevant factors that you look at when, in this case, when evaluating the use of force?
The primary elements that I look at are the event as it's unfolding at the moment that the use of force was taking place and the perception of the individual involved in the event itself. What did they perceive their position to be presented as? That's the ultimate thing that I have to look at when I look at a use of force case and come down to the nuts and bolts of things. It's at the moment the force was used, given everything else, at that moment, the perception of that person that was using force, what was their perception at that given second, and how would that affect the outcome.
Okay, we talked about the flashlight for a moment, the keychain flashlight. Did finding or noting that keychain being there, was that relevant at all in helping you determine where the altercation may have occurred or begun?
It helped create a picture in my mind as where it's possibly started at.
You were asked about blood flowing down or blood flowing back. In your experience, both from law enforcement and I guess more particularly from your experience as a, do we call you a fighter? Is that,
Sure.
Okay, as a fighter, what happens when you get hit in the nose?
Well, there's a variety of things that take place with a nose strike. I mean, there's one of the most immediate things because of the nerve at the base of the nose with a nose strike. It can cause immediate tearing of the eyes. If the blow is significant enough and it does result in bleeding, there's a free flowing of blood, which depending on the person, how it's flowing and so forth, it can fill the nasal cavity, drain out of the nose, but that can have an effect on your ability to breathe. Obviously, the most primary effect that it would have in addition to injury is the stunning effect that it can have on a person.
And in your experience with fighting MMA and other types, is getting in a blow like that early in a fight significant?
The training and everything behind it
Objection,
is...
Your Honor, it's calling for speculation.
Sustained.
If you were in a fight and want to get advantage over the other person, would a strike to the nose accomplish that?
Objection as to relevance and speculation.
Could be heard, but I don't want to...
Pardon, well, I don't know if that's in his experience or not. So,
Let me do a foundation.
Thank you.
You've been a fighter, correct?
Yes.
Just to remind the jury what we talked about this morning, you've actually done kickboxing?
Yes.
Does kickboxing include kicking and boxing?
Yes, basically it's boxing and you have to have a minimum of 8 kicks per round to basically maintain the level of kickboxing, but it's using your feet and your hands.
Okay, and as part of using your hands, you strike body blows, correct?
Yes, punching
And do you ever try and hit somebody in the face?
repeatedly, yes.
Okay, is that sort of a target focus for you as a fighter to hit somebody in the face?
It is, especially with the jab.
Okay, and with that as an experience basis, how successful is getting in the first shot to the nose in a fight?
Getting the first shot into the face or into the person, it can provide a various outcome. The primary thing is you let the person know you're for real, and it's devastating, especially if you have a hard punch. You know, the rule of thumb for us in training and everything else is the fact that when a punch is thrown, if you're the recipient, and you take that punch, that first strike, which is generally speaking 100% of what the person has because they don't try to just half hit you, you've taken a majority of their power, and if you survive the first punch, you can stay in the fight. For somebody that's not well schooled or doesn't have the same ability, it can have a devastating effect. So getting the first strike in and setting the tempo of the fight and letting the person know that you're on the attack and you're the person in control of the fight is very important, and especially in any combat type art, because he who controls the ebb and flow of the fight, the rhythm of the fight, generally can become victorious.
And you've seen this picture before, of course.
Yes, sir.
Is this consistent with a strike to the nose?
Yes, sir.
If this was the first strike of the fight, would it be, as you testified, a significant maneuver to control the ebb and flow of the fight?
Judge, I'd object as calling for speculation.
Based upon his experience and training, Your Honor.
But you're showing him a picture of something else, so you need to ask a different question, rephrase it.
Yes, Your Honor. You talked about your criminal justice degree, correct? But you talked earlier about the police academy. I want to see if there's any difference between the two. In your training, well, it's going to be difficult, but because you got your criminal justice degree after you started training as a law enforcement officer?
Oh, yes, I pursued my degree
Okay.
well into my career.
I'm going to try and separate the two. Did you learn any of your striking techniques or resistance techniques or takedown techniques in school for your criminal justice degree, or was just that in the academy and your further law enforcement training?
There was no physical courses like that required in my criminal justice degree. The criminal justice degree is geared toward more to educating you about the criminal justice system, about the courts, the processes, and things like that. The academy is about applying the enforcement of the laws. What laws are to be enforced, how to enforce them, physical ways to enforce it, how to conduct traffic stops, how to conduct everyday business as a professional law enforcement officer, whereas a criminal justice degree is kind of like the bookend, if you will, of criminal justice. It's how the system works in and of itself.
And having done it for now, I guess, 20, 25 years, did you enjoy being a law enforcement officer?
I did. I enjoyed being a police officer very much.
You think that it was, for you, a noble profession?
Absolutely.
Would you encourage or discourage, say you had a 20-year-old nephew or son, would you encourage them or discourage them from taking on a life of law enforcement?
Depends on the child. I have a stepson, for example, very physically fit, and I would encourage him without question to pursue it. My daughter, on the other hand, who doesn't like confrontation, who doesn't like that, I would not encourage that. But anybody who really wants to make a difference and is able to take on the stressors of that type of position, it's a very noble career, and I would recommend it to anybody.
You had mentioned early in the conversations about sort of the continuum of force, that a certain act can allow a response. So if you say to me, go over there and sit down, and I go, no, or even more colorful words, then you get to respond verbally. Is that sort of part of what we're talking about?
That's a piece of it, yes.
Okay. So, and that continuum of force sort of goes up the scale all the way and ends at deadly force, correct?
Yes.
Okay. And are there markers along the way that allows you to increase your response to force?
Absolutely.
So let's just say that I walked up to you and pushed you. What would an appropriate increase in force be based upon your training and experience?
I'm going to object as to relevance, as this relates only to police officers.
I'll broaden it. I want you to answer the question based upon your experience as an adult, based upon your experience as a fighter, and based upon your 20 years of law enforcement experience, and also based upon your expertise in looking at use of force events. So with that context, let me ask you a couple of questions about that. When you look at use of force events, does that go across the spectrum of use of force?
Yes.
Okay, we're not just talking about, you don't just specialize in use of force of deadly force, correct?
No, use of force is force, whether it starts from the very beginning, from verbal communications, and goes all the way up to and including deadly force. It's a very wide playing field.
So if you were aware of a situation of one of your, cadets or one of your people that you would end up helping to train, where they were just using inappropriate verbal force, screaming too loud or doing whatever, would you then counsel those people? Maybe I'm not saying it right.
Yeah.
Let me try again. When you do your use of force training within your experience, both law enforcement and as a trainer, does that include training law enforcement officers and whoever wants to be trained as to how to use even verbal force, where you use the command voice?
All of our force training, whether it's law enforcement or for individuals, the idea behind any level of training related to force is to explain the variables involved in deciding how to apply force and what justifies it. If somebody's being verbal, obviously we would recommend to them that if possible, our number one recommendation for everybody, if confronted by an aggressor, is try to avoid it if you can. But it all depends on your environment, your ability, the ability to leave, the ability. Sometimes people don't give you the opportunity to leave. Sometimes they could be yelling at you from 40 feet away. So all of these variables come into play. So when you look at each event, you have to take into consideration all of these variables. So if I was yelling at you and cussing at you from 40 feet away, my recommendation for you would be just to, you've got 40 feet, walk away, clear the area. If I'm up in your personal space within 6 feet, 3 feet, within arm's length of you, and now I'm getting that same hostility and everything, and I'm very animated, now that verbal confrontation becomes a more significant issue for you because of the distance that we've closed. So really it's very difficult to answer A and B because the totality of everything comes into play when you consider when and how force should be used.
Okay, so going back to my question I asked a moment ago, we were outside in the courthouse and I walked up to you and pushed you on the chest. What would your response be?
My
Objection, Your Honor, again, as irrelevance and speculation.
That was where I laid the foundation, Your Honor, as training experience.
Overruled.
My personal response, if you shoved me, I mean, again, we're taking this just, you walked up blind and pushed me, I would take a position of advantage and give you strong verbal commands and make sure that it was very clear to you that you made a mistake.
Would you punch me in the nose?
Objection, Your Honor, as irrelevance and speculation.
Again, his training and what level of response he would have.
But you're asking him what he would do in a situation just at that,
Okay,
a
I'll move on, Your Honor.
self-sustained.
Move on. I might just have a moment. Thank you very much for the question.
Thank you. Recross.
Mr. Root, you would agree with me that your understanding of what was happening at the exact moment of the gunshot comes from one person and one person only, correct?
Yes.
So your opinion that there was another option is based on the words from his mouth, right?
No, sir. My opinion
Did you talk
that
to
he
somebody
didn't have
else?
any other
Sorry, Your
options
Honor.
were
You could be allowed to answer his question.
My opinion that there was no other options was based on the totality of his training background and experience. The options that you're referring to really come into play based on what you're capable of doing, not simply just because this event's happening, you have another option.
Don't the options also depend on what the other person is doing? In this case, Trayvon Martin?
Well, absolutely.
So your determination as to what Trayvon Martin was doing at the time he was shot came from him, right?
That was one of the elements that I considered for that. But when you take the small portion of weight given to a statement and then you add in the other evidence that surrounds the event, the injuries and everything, to see if it corroborates it to a point that it seems plausible that this exactly is what took place, and everything lines up to say, yes, based on what I see here physically, the injuries and so forth, this all makes sense. So the opinion is that based on what he told me in combination with all the other variables involved, that's how I formed my opinion.
Yes or no? Do you know what Trayvon Martin was doing at the moment he was shot?
Yes.
You do.
You're asking my opinion. Based on the information I was given the opportunity, just like I could look at you and say, I don't know what Mr. Zimmerman was doing, I don't know what Mr. Martin was doing. If you're looking for me to say that I don't know if Trayvon Martin was doing this one specific thing, we're talking about the totality of how I formed my opinion. But you're asking me about what was he doing at that time. it appears clear through the evidence. If you want me to just surmise and say that, well, based on your perspective, he wasn't doing this, or George Zimmerman wasn't doing that.
I don't want you to surmise anything. I asked you a very simple question. Do you know what Trayvon Martin was doing at the moment he was shot?
I personally was not there, so I cannot attest to specifically knowing exactly what Mr. Martin was doing at the time. I can only base my opinion on the totality of the evidence as I've learned it throughout my exploration of this case.
Which includes your perceptions, or his perceptions as he told them to you, right? Didn't you say the defendant's perception is important?
The perception of an individual involved in any conflict is what you have to take into consideration when making a forced decision. So the perceptions, if I told you I had a perception that the Jolly Green Giant was jumping on me, that would be ridiculous. But if I was in this booth right behind here and said I had the perception that one of these wires were wrapped around my ankle, it was plausible. The perception is taking in the totality of the event as it unfolded to see if the perception that was related by Mr. Zimmerman was plausible.
Right. The perception that was related by him.
Absolutely, yes, sir.
And your conversation with him came about 2 or 3 months before his second-degree murder trial, right?
Sure, that sounds about accurate, yes, sir.
You were asked about testifying. This isn't the only time you've ever worked in a criminal case, right, on behalf of a defendant, is it?
No, sir.
I mean, you've been consulted on plenty of cases on behalf of defendants, right?
You're going to have to qualify that a little bit more and say I've been a bunch of cases on behalf of the defendant.
Right. Have you ever been retained, hired by a defense attorney to testify or consult with on behalf of a criminal defendant?
A criminal defendant, I believe retained, it's in my curriculum vitae, so I don't want to misspeak this, twice, maybe, I think. One would have been, I think, the Chambers case, and the other one would have been where I consulted, did not have to testify either by deposition or in trial. The name of the gentleman's escaping me, but it's toward the bottom of my CV.
This is just the first time you've testified in front of a jury.
Yes, in a criminal case in this way, it is the first time I've done this, yes.
And you mentioned the continuum of force, the force continuum, that applies to law enforcement officers, right?
The force continuum is a conceptual model. It's when you look at use of force, if you looked at Florida state statute, that's a continuum. It's a systematic approach to the escalation and de-escalation of force. The use of the words continuum came out of law enforcement, yes, but the actual application of the concept is regardless whether you're in law enforcement, you're in the military, or you're an individual on the streets of, Orlando. A continuum is still part of the conceptual variables that you consider when looking at a use of force event.
You were asked about getting punched in the nose. You don't know when George Zimmerman was punched in the nose during this confrontation, do you?
No, he was punched obviously repeatedly during the event. The exact time that the injuries to the nose were sustained, I couldn't tell exactly.
And it may have not been from a punch even, right? Didn't you say earlier it could have been when he hit it on something else?
No, I never said that. I never said that George Zimmerman hit his face on anything else.
Could it have been caused by something other than a punch?
In this event, I'm not aware of anything else that was present to have resulted in that injury, so
Okay, you're not aware of the concrete?
I do not believe that a facial contact of that nature with concrete without seeing other types of abrasions to the face and the eye areas, because when you're talking about the force significant enough to cause that damage to his nose with an impact on a flat, hard surface, you're going to have continued rollover, which is going to increase injuries in some area around the face. And it was pretty clear that the abrasions around the eyes or anything like that, so I wouldn't recommend the position that concrete caused that nose thing.
Well, let me ask you this. You've been punched in the nose before, right, during the fight?
Absolutely.
You didn't quit, did you?
I didn't quit?
Right. Did you keep fighting?
No, I'm a fighter.
So you kept fighting?
Absolutely. If you're a fighter, that's the whole purpose of entering into a fight is you fight.
And you've seen other people continue to fight after they've been hit in the nose, right?
I have seen both. I've seen people that when they've been struck, it exits the fight right there. The fight continues, but they are not able to respond in any form or fashion. And then I've seen others, and I mentioned earlier about the warrior mindset. Not everybody has that. So when you look at an individual, if they're involved in a physical altercation and they don't have that internal fire to be involved in that way, they're not going to fight. And when the fight starts, they're going to be that person that's just beaten. Where conversely, if you have somebody that's got the warrior mindset and they're struck, they're going to return in like fashion, and then you have two individuals with the same mindset going about one another, and you have tremendous damage to both persons because neither one of them is going to stop.
All right, my question was, have you seen people who have been hit in the nose during a fight and they keep fighting?
Yes.
Okay. Mr. O'Mara got on the floor here, and I got on the floor, and we did this little demonstration. You kept using your hands like this, like got to be 90 degrees, right? The two bodies, isn't that what you did?
I was trying, considering you were on the floor with a mannequin, I was trying to use my hands as trying to best relate that I could, that just being in this position, when you talk about 90 degrees, we're talking about maintaining a level or an alignment in some ways that puts them in a position. So when you talk about leaning back, maybe Mr. Zimmerman's coming up, but when you had the mannequin in that position, you weren't maintaining that same alignment, so the 90 degrees that you were referring to wasn't possible from what I was seeing. So I was trying to visually use to show that, you notice when one hand turns, the other hand turns. At some point, they were in this alignment that enabled them to have that type of entry wound.
Okay, well, in fairness, haven't we left something out? That is like the wrist and the hand and the arm. Can't that move independent of the body?
Sure,
Right?
but what you're talking about there is you're now wanting to say that it's this. Is that what you're saying?
Well, I'm asking you, if I'm laying flat on my back and somebody's over me like this, can I not shoot him at 90 degrees even though I'm on my back? Because
Can
my
you?
arm-
Yes, but when you also look at it from the perspective of actual discharging a firearm, if you try to hold any firearm and then hold like this to shoot, it's going to become much more complex. The average person isn't sitting there trying to do this, and they don't do it like you see in the movies where they hold it gangster style. The idea is when they draw a firearm, it's put to work in the manner in which it's drawn, which is by grip. So could he have taken the gun up and angled his wrist this way? Anything is possible. That doesn't make it plausible.
Okay, well, tell me then. Tell me what's not plausible about this. If I'm laying down on the ground and somebody's over me at any angle, I can always make it 90 degrees, right? I mean, it can be 90 degrees here, it can be 90 degrees here, it can be 90 degrees here. It depends where the other person is, right?
Everything depends on where you are in relation to that other person. It also depends on where the firearm is in relation to that other person. When you talk about the discharge of a firearm, and you talk about, and if you've done any kind of shooting, if anybody's done any kind of shooting, you learn very rapidly that the wrist position is not exaggerated. Why? Because that's not how you shoot. It takes very much conscious thought to remove yourself to put it so that you're at another position. Is it plausible? It's possible that the wrist was moving, and I'm not trying to say it's not possible, it's just highly unlikely.
So it's possible you can shoot somebody almost at any angle because we have arms and wrists and elbows, right?
Anything is possible, yes.
You were asked a question, I think before the lunch break about, was it your opinion that George Zimmerman's perception of the threat had disappeared because Trayvon had run off? Is that what you said?
Make sure I was very clear on this. When I listened to the call and I heard Mr. Zimmerman mentioning Mr. Martin in the recording where he was facing him, my perception of that call at that time, I sensed stress in his voice about the fact he was approaching him, looking at him, his hands was going toward his waistline. As he left, that tension diminished. That, to me, also reinforced what I've already heard from Mr. Pollack and saw from, again, reviewing the information in this case. He's not the confrontational one. He's not that I'm going to get on you type. When Mr. Martin ran, is what basically he's running, there's no immediate threat to him. His perception is he's taken off running, so he gets out, and that's where he is now trailing or following, I would say following the person, to see where they went, because that's what he was doing for them.
Well, didn't you hear the defendant say, I don't want to give up my phone number because I don't know where he is?
Yes.
Doesn't that indicate to you that he still might be a little concerned about what's going on?
Mr. Zimmerman?
Yes.
Oh, absolutely. You know, but I mean, when we look at it that way also, when we're talking about timelines, if we're thinking about the T, and he took off running to make it home, it's my understanding home wasn't that great a distance away, considering his age, how come he wasn't able to make it the exact distance? If he's still in the area, it's presenting a concern for Mr. Zimmerman because he's lost complete sight of him. He's not running at the end of his distance, even though the visual acuity is minimal because of the darkness. So now you're looking at an individual that is walking back and he's uncertain as to whether or not he's actually still there, so he doesn't want to give out his phone number.
Let me ask you one more question about the firearm. Were you aware that the defendant was trained by a federal marshal how to shoot?
Yes.
You also said that interviews, you feel like an interview is better if it's delayed.
Not all interviews. We were talking about the use of deadly force, and the comment was made to me about, for example, using references for law enforcement. It is a common practice to delay the interview because of the known memory loss issues and to extend the time before you conduct a thorough investigative interview of a police officer.
But that's not what you... Go ahead.
My interpretation when I was asked that question is it just seemed reasonable that if we extend that courtesy to law enforcement, it can be extended to anybody.
But that's not what you did as a police officer, right? I mean, when you arrested somebody, a suspect for a crime, you didn't wait a couple days to interview him, right? Didn't you interview him right there?
Of course not, because the idea is, and I mean, to be very honest, when you're a police officer, you're told all the elements of the crime to the best of your knowledge. You're given the discretion to make a decision as to whether or not an arrest is warranted, and you base it off the facts that are known to you at the time. So when you ask for an interview and you're interviewing a bad guy, if it happens to be a homicide, which I have investigated homicides, if it happens to be a homicide, you're going to go in right away, and if the individual says, I want a lawyer, they're getting their period of time where they're not going to have to talk. That's their lawful right. The investigator doesn't wait. The investigator goes ahead in and tries to get whatever information he can, but he also uses the totality of the circumstances that he finds himself in so that he forms his questions and he makes a determination based on those interviews whether or not an arrest is warranted. But I wouldn't wait 3 days unless there's no rush to make the arrest.
And you're aware that the defendant spoke with his friend, the best friend that I've asked you about 8 hours after this event?
It's conceivable, yes.
And just to be sure, just to be certain, you're not an expert in memory retrieval. That's not what you're telling us.
Memory retrieval? No, sir.
Right.
No.
May I have just a moment, Your Honor? That's all I have, Your Honor. Thank you.
Thank you. Redirect?
Just on the new issue that was addressed, one issue, you had talked about this warrior mentality or warrior mindset.
Yes, sir.
Can you give the jury any insight based upon the evidence in this case as to whether or not Mr. Zimmerman evidenced a warrior mindset or not?
Based on the information I received from probably one of the most important persons I talked to with that regard was Mr. Pollock, the gym owner. And his description and everything about Mr. Zimmerman was not one to enter in the ring. He was not confrontational. Everything that I've reviewed in this case would indicate the opposite. He was not the type that had what we would refer to as a warrior mindset, that inner fire that compels you to be a fighter, that compels you to be that person that wants to get into the ring to test your skills against another person.
Was there anything about but for the gunshot, the lack of injuries on Mr. Martin that helped you with that decision?
Based on the injuries that we've all seen for Mr. Zimmerman and the lack of injuries on Mr. Martin, I would take that as evidence that he didn't have any striking. Even though he's on the ground and in this tussle, he did not do anything of any significance that would have been able to even result in an injury to a man. So that would support, again, the same information that I already derived from another source.
He didn't even land a strike, at least one that left a mark, did he?
I'm going to check that as calling for speculation.
Sustained.
How about any evidence gathered from this event that suggested that Trayvon Martin did have a warrior mentality or
I'm gonna object to
mindset?
That is beyond the scope and in violation of the amended motion.
My response?
Sustained as to the violation.
The door was opened, Your Honor. It was this prosecutor that asked that very question. I'm just asking him to focus.
And you've already asked your questions about that, so I think that...
I'm now asking about Mr. Martin, not Mrs. Zimmerman any longer.
My objection, my ruling remains sustained.
Yes, Your Honor. Was there any evidence in the case that you've looked at that would suggest that even through the 45 seconds worth of screaming that the attack stopped?
Judge, I'm going to object to that as calling for speculation.
Well, you asked him if he was aware of any evidence overall.
No, I saw nothing that would indicate that to me.
Thank you. Nothing further, Your Honor.
Okay, thank you. May Mr. Root be excused?
Subject to recall, Your Honor.
Okay, thank you very much, sir. You're...
May we approach on the issue of recall for a moment? Just,
We can address that later, but I will tell him you're subject to being recalled. And then we'll address the issue about recalling later. You're excused from the courtroom today, but you're subject to being recalled. Please call your next witness.
I just have a moment.
Yeah.
Thank you for the time, Your Honor.
Okay, thank you. Call your next witness.
Ms. Bertolone?
Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
You may proceed.
Thank you. Got the name, ma'am. Could you state your name, please?
Olivia Bertolin,
Okay. And Bertolone, if you would spell that last name?
Bertalan.
And at one point, back in February of actually early 2012, did you live in the retreat at Twin Lakes area?
Yes.
Have you since moved out?
Yes, I have.
Okay. Are you married?
Yes, I am.
Do you have any children?
2.
Okay. And their ages?
2.5 and 4 months.
Okay. Going back then to when you still lived at Retreat View Circle, did an event happen at your residence where a crime was committed?
Yes.
If you would explain to the jury what happened with that.
I was home on a Wednesday with my son. He was, I think, 9 months at the time. And I heard someone ring my doorbell repeatedly. So I went to check upstairs because I didn't have a peephole. And I saw 2 young African-American guys ring my doorbell repeatedly, and they kept on looking up at the window. And I called my mom because I didn't know what to do. And they left. Then after a while, I went back upstairs to check one more time. And they were walking in front of my house. One came towards my house. And I was on the phone with my mom at the time, and I started crying. And I called the police. They broke into my house. I heard some bangs downstairs. The dispatcher told me to grab any weapon I had because I had my son in my arms. He had woken up, and just prepared to use it if I had to. The guy was I was locked in my son's bedroom, and he was shaking the doorknob trying to get in. And I was sitting there with a pair of rusty scissors and my son in one arm, and the police came and they ended up leaving.
And do you recall approximately when this happened?
August 3rd of 2011.
Okay. And did you then take a place of refuge or hiding while this was occurring?
Sir, yes, I did.
And where did you go to hide?
My son's upstairs bedroom.
In the closet?
I wasn't in the closet, I was in the far corner because the closet was closer to the door. So she said to get away, as far away from the door as possible.
And did you have your son with you during that time?
Yes, I did.
Did the people who were downstairs at some point, did they leave the house?
Yeah, once, I guess they escaped before the cops got there.
And did they take any items with them?
Yes, they did.
What did they take?
My camera, our laptop, they tried to get our TV, it was unhooked, but he had it hooked up to our computer so they couldn't get it off. I think there was something else, but I can't remember what it was, but definitely our camera and my laptop.
And at some point, then one of those people, or at least one of those people, were arrested and found and arrested and charged with that crime?
Yes.
And do you know what happened? Do you know the person's name?
His name is Emmanuel Burgess.
And is that the reason why you moved from that area?
Yes.
Nothing further.
Just for you, thank you. Ms. Berlin, good afternoon. You had some contact with George Zimmerman after that event, did you not?
I did.
Okay, and
Direct, outside the scope of direct.
Judge, it's the basis of her testimony, I believe.
I would ask that that be proffered at the bench.
Well, we can't proffer to the bench. Ladies and gentlemen, if you'll please put your notepads face down on the chair and follow Deputy Jarvis out of the courtroom. Please be seated. You may do your proffer.
Ms. Berlin, I believe you said that this crime happened to you on August 3rd, 2011.
Yes, sir.
Did you have contact with George Zimmerman that day?
I did.
Okay, when I say George Zimmerman, I'm referring to the gentleman seated at the end of the table to my left.
Yes,
Correct?
sir. Yes, sir.
All right. He came to your house,
Yes.
and he gave you his phone number?
Yes.
And the reason he came to your house, as he described to you, was that he had heard you had been a victim, right?
Yes, sir.
And you talked to him about it, correct?
Yes, sir.
You described the people that you saw at your residence?
I believe so.
You described them as two people as opposed to one?
Yes.
As males?
Yes.
As black?
African American, yes.
As teenagers?
Yes. I said they looked young.
And that wasn't the only conversation you had with this defendant about that case and you becoming a victim, right?
Right.
Is it correct to say that you and he talked about this approximately 20 times after that?
Probably around there.
I'm sorry?
Probably around that amount.
And you discussed with him the fact that the person had not yet been caught?
I'm sure I did. I spoke to several people about it.
And the person wasn't caught until after you moved out of the retreat at Twin Lakes, right?
He was arrested in December. Then he was released because he was a minor, and he was arrested again after we moved out.
After you moved out.
I believe so. We got a letter after we moved out. I'm not sure the exact date of his arrest.
And another thing that you and George Zimmerman discussed was where you believed or he believed that particular suspect lived, right?
I'm sure we discussed that.
And you discussed that he lived near the back entrance of the retreat at Twin Lakes?
Yes.
Your Honor, I have other questions for, but they don't relate to her contact with the defendant.
Okay.
So that would be the extent of the proffer, I believe was what was objected to.
I withdraw my objection.
Okay, thank you. Let's go ahead and bring the jury back. Please be seated. You may continue.
Thank you, Your Honor. Ms. Berlin, I believe you said this incident happened to you on August 3rd, 2011.
Yes, sir.
Okay. That day, did you get a visit from a man named George Zimmerman?
I did.
All right, and is he the gentleman seated to my left at the end of the table?
Yes.
Used to live in your neighborhood, right? He used to live in your neighborhood.
Oh, sorry, yes.
And he actually came to your house that day, correct?
Correct.
I need you to just speak out
Sorry.
loud. And he talked to you. The reason he came to your house, he didn't know you, right?
Right.
He came to you because you had been a victim of something, right?
Yes.
And you described for him what had happened to you that afternoon.
Yes.
And you described to him the people that had victimized you, right?
Yes.
And you described the number of people.
Yeah.
How many did you tell him?
2.
And did you describe the sex of the people?
Yes.
And what was that?
Male.
Did you describe the race of the people?
Yes.
What was that?
African American.
Did you describe the age of the people?
I didn't know the age for sure, but I'm sure I told him I assumed they were late teens. They looked that age.
And after that, you and he continued to talk about that very case, right? Mm-hmm. Yes?
Yes.
Okay, approximately 20 times, is that fair?
Yeah.
And you and he discussed that the person or persons involved had not been caught, right?
Right.
And you discussed that it was your belief, and I say your collectively, you and him, that that person responsible, or one of the people, actually lived in the retreat at Twin Lakes, right?
It was confirmed by the police.
That they
So-
lived inside.
Yes.
And you discussed that with the defendant.
And other neighbors.
And you discussed that that person lived in retreat at Twin Lakes near the back gate, right?
Yes.
And then it's your understanding that at some point that person was arrested
Yes.
and released prior to February of 2012.
Correct.
You have you watched the proceedings in this trial?
Briefly.
What parts did you watch?
I believe I saw his uncle testify.
Who else?
I don't know any by names. I haven't watched very much.
Have you tweeted about this case?
Not since, no, I have not.
Not since what?
Maybe last year when it first happened.
You haven't tweeted about this trial
I don't believe so.
this week?
I don't believe so.
You do have a Twitter account, correct?
Yes.
And you follow, you actually follow Mr. O'Mara, do you not?
Yes.
And you follow an account or a site called Zimmerman Legal Case, right?
I do.
And you have been on Nancy Grace
Yes.
in regards to this case?
Over a year ago, yes.
I have just a moment, Your Honor. Ms. Berlin, thank you for your time.
Redirect.
Thank you.
Just a few follow-up questions, ma'am. When Mr. Zimmerman came to you to talk to you about having been victimized by a home invasion, did you consider that strange?
No.
Were you appreciative of his efforts to help you out?
Very.
Tell me about that.
We were terrified when this happened, and when we came home after we were having car troubles, and we came home, and he was just saying that he wanted to make sure we were okay. We weren't home, my sister was, and she didn't answer the door because she was scared because of what had gone on. So I was just appreciative that he was offering his hand and had told me I could spend time with his wife if I needed to go somewhere during the day because I was so afraid.
He told you that his wife Shelley was a nursing student, correct?
Correct.
The objection has to hearsay.
Did he tell you, what did he tell you about his availability, if any, of his wife to be there for you if need be?
The objection to that is to hearsay and relevance.
It's,
Well, I'm really having a problem with the relevance.
I was just following up on, okay, Your Honor, I'll just focus it again. Were you aware that Ms. Zimmerman was there for you as well, if need be?
Yes, sir.
Did you then at some point, shortly thereafter, go to the homeowners association and discuss the issue of the home invasion?
I don't believe I went, my husband did.
And then, in addition to your conversation with George Zimmerman, did you talk to other people about what happened to you?
Yes.
Who's that?
A couple of my neighbors, neighbor named Pete, another neighbor, Chris.
Was this home invasion then something of a point of conversation because of the trauma that you had with it?
Yes.
Matter of fact, did Mr. Zimmerman, after the homeowners association that started Neighborhood Watch, did he bring to you a lock to help you with the sliding glass door?
Yes, he did.
Did you consider that weird or unusual or strange?
No, I was very appreciative.
Were you made aware that there was a issue with problems with the sliding glass doors in your neighborhood?
I don't believe so.
Was it actually how they got in the house, the sliding glass door, or another?
Yes.
So they actually came in through the back sliding glass door?
Mm-hmm.
Did
Yes.
this lock then help secure that problem?
Yes, it sits behind it, and it locks it tight so they can't pull it open.
And before you moved out, you even had, didn't you get a dog to help?
Yes, we did.
Was that part of trying to just stay more secure in a neighborhood where you've been burglarized or invaded?
Yes, the cops told us to get a dog.
You know the person who was arrested was Emmanuel Burgess, you said?
Yes.
And that he was released?
Yes.
Did you know that he was rearrested on February 6th of 2012?
I didn't know when. I got a letter after we moved out, so I didn't know exactly when he was arrested.
Did any of your interactions with Mr. Zimmerman in this regard leave you with some impression that he was just too involved in trying to help you out?
No,
Did you think that his behavior was helpful to you?
very.
Still have the dog?
Yes.
Thanks very much. Nothing further.
Thank you. May Ms. Bertolon be excused?
She may.
Yes, sir.
Thank you very much. You're excused. Please call your next witness.
Defense would call Robert Zimmerman Sr., Your Honor.
Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Name, please.
Thank you, Your Honor. Good afternoon, sir. State your name, please.
Robert Zimmerman.
And live here in Central Florida, correct?
Yes, sir.
How long have you lived in Central Florida?
Almost 7 years.
Okay. You know George Zimmerman as your son, I imagine?
Yes, sir.
Okay. Understand, of course, he's here on a second-degree murder charge, right?
Yes, sir.
I'm going to limit my questions to you to an event where you had an opportunity to hear what we have been calling a 911 tape, or Miss Lauer's 911 call. Do you know what I mean when I ask you about that?
Yes, I do.
It is a tape that includes in it some screams and a gunshot. Have you heard that tape?
Yes, I have.
We have it available. The jury has heard it dozens of times now. I'll only play it for you if you need it to hear it again, but do you have a memory of it such that you remember listening to it and forming an opinion as to who you heard?
Yes, sir, I do.
If you would just tell me the setting or the circumstances around the first time that you heard it.
I believe the first time I heard it, it was on the 3rd floor of this building. It was in the state attorney's office. I was there, I was put under oath. They asked me some questions. As I was getting ready to leave, they asked me if I would mind listening to this tape. I said, certainly. So they took me in a fairly small room where there was a computer. They provided me headphones, and they reminded me I was still under oath and would I listen to it. I said yes, so I listened to it. And then they asked me, did I recognize the voice?
And what did you tell them?
I told them, absolutely, it's my son George.
Is that an opinion that you still have through today?
Certainly.
Nothing further on.
Thank you, Cross.
Good afternoon, sir.
Hi, sir.
I think you've listened to it 6 times, is that correct?
I'm sorry?
I think you've listened to that recording 6 times, correct?
No,
You have not?
no.
Okay. I may have a moment, Judge.
Yes, you may.
I've listened to it a number of times. I have no idea if it's 6 or,
Oh, okay.
I would probably say at least 6, but
More than 6 times?
I would
least-
guess at least 6, but
Okay.
I really
Thank you very much.
can't
sir.
be accurate.
Thank you, sir.
Okay, any redirect?
No, thank you, Your Honor.
May Mr. Zimmerman be excused?
Yes, Your Honor.
Subject to recall, Your Honor.
Okay, thank you. You're excused from the courtroom, subject to being recalled, sir. Thank you. Call your next witness.
I think this might be a good time for a break, if I might, Your Honor.
Okay, ladies and gentlemen, we'll take a 15-minute recess. If you'll please put your notepads face down on the chair and follow Deputy Jarvis back into the jury room. Please be seated. Is the defense going to be calling any other witnesses?
No, Your Honor.
Okay, so after the recess, I'm going to ask Mr. Zimmerman about whether or not he wants to testify. But at this time, Mr. Zimmerman, were there any other witnesses that you wanted your attorneys to call on your behalf, sir?
No, Your Honor.
Okay.
For this hearing?
For this trial?
Trial.
You've been here through the trial, and we've had, we've had 40 witnesses that were called by the state and 19 witnesses called by the defense. Some of them were called, I'm sorry, I'm talking to Mr. Zimmerman. Okay, some of them were called a couple of times, such as Ms. Singleton, so it's really less than 19. My question to you is, Mr. Zimmerman, were there any other witnesses that you wanted your attorneys to call on your behalf at this trial?
No, Your Honor.
Okay, thank you very much. When we get finished with the recess, I'm going to ask you about whether or not you're going to testify.
Yes,
So
sir.
take the time you need to talk to your lawyers.
Thank you.
Okay, thank you very much. Court will be in recess.